Welcome to Tech Bytes and News, your daily roundup of articles featured in Hacker News. Today, we're diving into a fascinating development in the world of AMEI and copyright law. The U.S. Copyright Office has issued a statement. Purely AI-generated art simply can't get copyright protection.
That's a pretty significant ruling, isn't it? I mean, it's been a gray area for a while now. What's the reasoning behind this decision?
Essentially, the Copyright Office argues that current copyright law requires human authorship. Even incredibly detailed prompts don't grant the user enough control over the AI's creative process to be considered the author. The AI interprets the prompt, and the resulting artwork reflects the AI's interpretation, not the user's direct creative expression.
So even if you spend hours crafting the perfect prompt, iterating and refining it, you still don't own the copyright? That seems counterintuitive, especially given the level of skill some people have in prompt engineering.
Exactly. It's a bit of a blow to those who believe their prompt engineering skills constitute authorship. The Copyright Office uses the example of a Gemini-generated image, a cat smoking a pipe and reading a newspaper, where the AI ignored parts of the prompt and added its own elements, like a random hand. They contrast this with Jackson Pollock's work. He didn't precisely control the paint's placement, but he controlled the overall composition, colors, and texture. It's about the degree of human control, not the predictability of the outcome.
I see. So it's not about the complexity of the prompt, but the level of direct control the human has over the final output. That's a crucial distinction. But what about cases where AI is used as a tool, not the primary creative force?
That's where things get a bit more nuanced. The Copyright Office clarifies that using AI as a tool to assist in a creative process, like using AI to add 3D effects to an illustration, doesn't necessarily invalidate copyright. The AI-generated elements themselves might not be protected, but the overall work, if it retains significant human expression, can still be copyrighted. Think of it like using Photoshop. The software is a tool, not the artist.
Right, a helpful tool. So it's a matter of distinguishing between AI as a collaborator and AI as the sole creator. What about the case of Théâtre d'Opéra Spatial? That Mid-Journey image caused quite a stir.
Yes. That's a perfect example of the complexities involved. The creator fought to register it, but this ruling suggests that such purely AI-generated works are unlikely to receive copyright protection under current law. It highlights the ongoing debate and the need for clearer guidelines.
So the Copyright Office is essentially saying AI is a tool, not an artist, for now. But they also acknowledge that this could change as AI technology evolves, right? This is a rapidly evolving field.
Absolutely. The report suggests that future AI systems might allow for such a high degree of user control that the AI's contribution becomes almost mechanical. But for now, the bar for human authorship remains high. They're also planning further reports on the implications of training AI models on copyrighted works, which is another huge area of concern.
This is a really interesting and important discussion. It's going to have huge implications for artists, developers, and the legal landscape as a whole. Thanks for breaking it down for us.
My pleasure. And that's all the time we have for today's Tech Bytes and News. Thanks for listening, and we'll catch you next time. Goodbye.
Bye-bye.